Oh, good job. Good morning, everyone. Welcome to the Santa Barbara County Planning Commission meeting of the 2nd of August, 2017. Please join us for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning, Mr. Villalobos. Hope your summer is going well. Will you call the roll and give us the TV coverage announcement?
Yes, thank you, Mr. Chair, and good morning to everyone. Planning Commission hearings are televised live on County and Santa Barbara Television, CSB TV, Channel 20 at 9 a.m. in the South Coast, Lompoc, San Ynez Valley, San Maria, and Orchid areas. Rebroadcast of Planning Commission hearings are on Fridays at 5 p.m. on CSB TV Channel 20. Today's hearing will also be streamed live on CSB TV's website, and maybe it will be available to download in a day or two. Now for the roll call: Commissioner Brown,
Here.
Commissioner St. John,
Here.
Commissioner Freeney,
Here.
Commissioner Blau,
Here.
and Chair Cooney.
Here.
Thank you.
Thank you. Good morning, Ms. Black. How are you?
Good morning, Mr. Chair, members of the commission. I'm fine. Nice to be back with you. It feels like it's been a while. For the agenda status report, we do have one item on our agenda, and we're ready to move forward with that item. Turning to the projection report, we have a hearing scheduled next Wednesday, August 9th in Santa Maria. And as you can see, there are two consent items on and then one permit item on for your commission's consideration. Our next hearing will be on August 30th. That'll be in Santa Barbara. And we do have 3 permit items on that day, including the Tehigas landfill, which I believe was previously shown on August 9th, and we've needed to move that a bit. September 6th, the week of Labor Day, there are no items projected for the commission at this point in time. I think it would probably be safe at this time to go ahead and make a motion to cancel that meeting. We do have a relatively full hearing on September 13th. That'll be in Santa Maria, and as you can see, there's one permit item on the cannabis briefing that the commission requested. And then we do have a cannabis-related ordinance amendment we're proposing to bring to your commission for a recommendation to the board, and that's on non-conforming status determinations under Chapter 10 for medical marijuana facilities, and establishing an amortization period under that ordinance as well. So we'll obviously do the briefing first, give you a bit of more context as to the full scope of the project, and then we'll hone in on that particular ordinance provision. And then September 27th, we are scheduled to meet in Santa Barbara, and you can see that there are several permit items on that day, as well as the APCD greenhouse gas mitigation update that your commission requested at a previous meeting. And that's about as far out as we project right now.
Any idea about any of the oil and gas projects? Mr. Cantle had indicated maybe one late in the year. And I got an inquiry about the Oak Hills Estates tentative track map.
So, Mr. Chair and Commissioner Brown, with respect to the oil and gas projects, I think it's unlikely that you'll see any of those projects this calendar year,
Okay.
perhaps early next calendar year, and I'm basing that on the fact that I've not seen an EIR yet
Okay.
on any of those projects as a public draft. So I suspect it won't happen this year.
Okay. And how about the Oak Hills Estates?
Oak Hill Estates, we circulated an EIR. We received comments that were very unexpected from Fish and Wildlife about butterfly habitat, I believe. And so we've revised and recirculated that section of the EIR. I don't think the public comment period has closed yet, but I would expect that we would see that one, certainly in the
By
next
the
few
end of the-
months.
Okay.
Yeah.
Great. All right. Thank you.
Any other questions or comments about the status report? Seeing none in the North County, none here. We can move on to the public.
Mr.
You
Chair,
had
did you
something.
want to take up
Oh, they
canceling the
continue.
September 6th?
We can do that now, yes.
I'll make a motion to do that, to cancel the September 6th meeting.
We have a motion to cancel the regular meeting of September 6th. Is there a second?
Second.
Thank you, Commissioner St. John. So we'll have a roll call on that, please, Mr. Villalobos.
Commissioner Brown,
Aye.
Commissioner St. John,
Aye.
Commissioner Freeney,
Aye.
Commissioner Blau,
Aye.
And Chair Cooney.
Aye.
Motion passes 5-0.
Thank you very much. This is the time when we invite public comment on anything of concern to the public and the Planning Commission, except for matters on our agenda today. Do we have any public comment?
No, sir.
Requests to speak? We don't have any in Santa Barbara. Anything in Santa Maria? Gentlemen?
We have no one in the audience in Santa Maria, so it's just Larry and I.
Okay. So I think we can assume there is no request to address the commission today and move to the Planning Commissioner's informational reports. Commissioner Brown.
Thank you, Mr. Chair. Last week, I attended the scoping hearing on the cannabis ordinance, EIR, and it was an interesting process because it just feels as though this process is sort of going backwards rather than forwards as what we normally experience. There were many cannabis people who are related with all farmers, businesses, but very few community members. And those in the community who've contacted me are sort of befuddled by what the process is and where they get information. So I feel that, and I'm glad to see that we have a very robust hearing on the 16th, but I'm a little concerned that I don't have an understanding of what the rollout is for the Planning Commission for reviewing this ordinance. The draft EIR is coming out September, I think, mid-September, I understand, or sometime September. But I would really like to, if possible, I'd like to see us get ahead of the information curve, if you will. And I'm not quite sure how to do that. I've been doing a lot of research on my own, and interesting what I'm finding. But I'm just wondering if I can give Ms. Black a listing of documents I'd like to see for our September hearing. And maybe in scheduling future hearings, I spoke with Kathy Fisher for a brief period of time this week. Very interesting what she had to tell me about ag and what she's doing, and I'm wondering if that might not be worthwhile to get her in here to talk about it, because as I see in these land use tables, which are kind of, a lot of people don't understand them, it's cannabis-related activities are being allowed in all sorts, in ag 1 and ag 2. So with that, perhaps you have some comment on that?
So, Mr. Chair and Commissioner Brown, it would be extremely helpful to hear from you what documents you'd like to see for the September meeting.
Okay.
We'll also put together kind of a master schedule so that you have that. I believe that Dennis Bazanich and Kathy Fisher, as well as my staff, are going to be at the briefing for the commission, because remember, this isn't just land use.
No.
This is much, much more than land use. Right. And so so I think I think the intention was that she would be at the briefing, so you'll hear from her as well. And
can we just email you a list of what I think would be important? I'm interested in our scenic highways information, and because that would affect if it's growing on ag in the Gaviota Coast or off of 154, and there's some other documents that I'm not familiar with. So
sure.
Okay.
And then the other point I wanted to make is you said cannabis would be allowed in these zone districts. This is just what we're studying right now. So I want to be really careful that we don't presuppose that what we're studying is what will actually be recommended by your commission and approved by the board.
But I don't think people in the community understand. They don't have that information, so they're like, oops, wait a minute, we're going to put this in the MU zone district? What?
Right.
We just went through a community planning process where we're hoping to put housing there, so
right.
it's confusing. Right. So it's just, there needs to be some clarity, and I'm hoping through our meetings that we will provide that clarity and that information and that education to everyone.
And Commissioners, I just want to let you know, we will be briefing the Montecito Planning Commission, probably not quite in as much depth. We'll see how far they want to go, but at their meeting in August as well. So just if you want a little pre-hearing on it.
And then,
and then if you really are interested, you could watch the board's hearing from July 18th, I think it was.
11th, wasn't it? 11th.
July 11th?
I think it was.
Maybe it was the 11th.
Yeah.
And kind of see what the board, where the board's at in terms of being briefed on the entire project.
Thank you.
Yes, thank you, Commissioner Brown. It does seem that in this instance, because it does cross various departments of the county, the board has taken the leadership and has formed a subcommittee to think through a lot of the ramifications, and we are catching up, but thanks to staff for including us, and we look forward to over the next month really being in a position to advise our constituents on the impact on planning, potential impact on planning, because of course the ordinance isn't yet adopted. Any other informational report items, Commissioner Brown?
I just have a question on something that Commissioner Cooney said to follow on from you. So when we ultimately see this, the standards will be presented to us in what way? As though it's being applied to all zone districts, or just, I'm not, how, can you just explain that, please?
Mr. Chair and Commissioners, it'll be an ordinance package. So it'll be a proposed ordinance amendment which will not necessarily allow every cannabis type of land use in every zone district, but rather be more selective than that.
And who's going to make that determination? The board or staff or?
Well, ultimately, the Board of Supervisors will decide where.
I understand
we
that.
are trying to balance a reasonable range of, you know, the most comprehensive study of the issue,
Yes.
so that we can narrow in, as opposed to narrowing in and then wanting to go further out
Right.
in environmental review. But ultimately, we'll be making a recommendation to your commission and to the board.
Okay, thank you.
And we think also that it's valuable to have an opportunity for the public, multiple opportunities for the public to express concerns, because that will inform what the eventual ordinance looks like.
Absolutely. And we can summarize at our briefing in September, public input opportunities to date and what we anticipate in the future as well.
Okay. Anything else? Informational report? Not seeing any. We will move on to the minutes. We have two sets. The first is June 28, right? Any comments, additions, questions, or a motion on June 28? Commissioner St. John.
If no one has comments, I'll move approval.
And
I'll
Commissioner
second.
Brown. We have a motion and a second to approve without change the minutes of the 28th of June. We'll need a vote on that, and I'll be abstaining as I was not present.
Commissioner Brown.
Aye.
Commissioner St. John.
Aye.
Commissioner Farini.
Aye.
Commissioner Blau.
Aye.
And Chair Cooney.
Abstain.
Motion passes 401.
Thank you, everyone. We have then the last meeting, the 12th of July.
Make a motion to approve.
Second?
The motion has been made and seconded. Any comments before we move to a vote? Not seeing any. Okay. Roll call.
Commissioner Brown.
Aye.
Commissioner St. John.
Aye.
Commissioner Farini.
Aye.
Commissioner Blau.
Aye.
Chair Cooney.
Aye.
Motion passes 5-0.
Thank you very much. We're moving to the director's report, Ms. Black.
Yes. So this morning, I have two board hearings to report on: the 11th, or excuse me, having a hard time with my dates this morning, July 18th and July 25th. And the 18th was a day where the board discussed two water-related items. One dealt with service connections, and I think your commission is aware that both water districts and sanitary districts are less willing, able to provide definite service commitments for projects, and this is particularly problematic with maps that your commission and sometimes the board considers, because we expect under our policies for people to have a pretty definite service commitment. So we talked to the board about that, and you know, acknowledging that we really don't have control over the districts. We can't force them to say they will hold capacity for certain projects that your commission approves. The board agreed that the best approach was to get the most commitment that we can from the districts to understand what their water supply or sanitary capabilities are, and then to do a buyer beware notice, particularly on maps, so that people understand that when a map records, they don't have a certain, you know, they don't have a can and will serve letter to provide service to those, and situations can change. And I think this issue was especially highlighted in the drought. So I think that was a good outcome, a realistic outcome, and one that we will be codifying, and you'll see conditions drafted a little bit differently in the future than you have in the past. The other item was on water wells, and a couple years ago, Environmental Health Services went to the board at the behest of the Montecito Water District to discuss potential moratorium or some other way of permitting wells in districts. And so that item, in a slightly different form, went back to the board, and the board, after quite a significant discussion, I wasn't there, but I did watch the hearing after the fact, asked the Environmental Health Services and our department to do three things. The first was to establish hydrogen sulfide monitoring for wells, and to have a plan if hydrogen sulfide is encountered. And then the second and the third related to water, hopefully I'll say this right, water wells for non-agricultural land uses in areas that are served by a water district. And there were two issues that the board wants the departments to address. One is they want to have flow meters on those wells when those wells are approved. And secondly, they want us to come back with consideration of a discretionary process for consideration of those wells. So we are collectively looking at that, and we'll be going back to the board at a later date. And then on, any questions before I move on?
Yes.
I
was going to let you pick when you wanted your questions. So with regard to wells, this is a big change. And of course, we've been told for years that California law gives a certain amount of right to drill. And I think people have relied on that general understanding. So do I understand that the proposal the department is being asked to review is in the course of a project that we might see for building permit or that is a land use permit related to building a new structure or remodel or whatever? There's the water source is disclosed as a well, that there would be some discretion in the department to say we're going to approve this but not a well because you're served by one of the water districts?
Mr. Chair, I guess the reason I hesitate is we already have policies that somewhat address this issue. So I think we have land use development policy 5, I think it is, and a corresponding coastal development policy, or a local coastal program policy, which basically says if you're served by a water district, you get your water from a water district. So the difficult situation has been, what is if service is available? What does if available mean in terms of especially larger estates during a severe drought where water is not available.
Or
the-
partially
at the
available.
quantities that property owners want. So we saw quite a proliferation in the development of wells, primarily in Montecito, but in some other areas as well, on properties that have water district service. So I think that's kind of the issue the board is trying to get at in looking at this. That being said, it's not that big a change in policy, at least not in the coastal zone, because in the coastal zone, water wells are subject to a CDP or a CDH, so they are discretionary already. So it's really extending that process into other areas of the inland, other portions of the county in the inland area. So we'll see where this ends up, because it does raise a lot of issues that you raised in the very beginning part of your comment, which is that there is quite an expectation that people have pretty unfettered rights to their water. So we're trying to figure out, okay, if we have a discretionary process, what will that discretionary process do to help resolve some of these issues? And is it the best way to go? So we're looking at it. And we'll, obviously, if we move forward with ordinance language, I think because it's a land use and development code ordinance change, presuming that it would be through our department, then it will come through the commissions.
Well, you don't have any estimate of the time frame for making these decisions?
We don't right now. I mean, this is kind of an unplanned piece of work. So it's not in our work program. We have to figure out how we can staff it, and if we want to go back to the board for clarification before we proceed, or if we're going to just draft ordinances and see what happens. We haven't reached a conclusion on that yet. I would imagine we would in the next month or so decide how we're going to move forward.
Well, I applaud the board for initiating the review, because it did get out of hand during the recent drought. We had instances in the first district where water was being, wells were being drilled or improved or deepened to export water to Montecito, and water trucks were running up and down the streets delivering water at significant cost, but cost is not apparently a restrictive factor. So I think it's well that we take a good look at it.
And Mr. Chair, on that issue of drilling a well and then exporting water, our ordinances already do address that. And you have to have a major conditional use permit to export water from one area into another. But that doesn't mean people went through that process during this drought. But there is a process that needs to be adhered to.
Thank you. Commissioner Brown.
So when you say export water, you mean by truck or wheeling water or some other?
That's what I meant.
Okay. Well,
Not by pipeline, but there is a litigation
Slippery Rock
pending in Goleta,
Right, I was wondering how
which
that might
raised the issue on a broader scale
Right.
of
Yep.
groundwater basins.
Yep.
And
Okay. Very complicated.
It is.
It's a deep subject.
Okay, and
Okay.
then next meeting.
So the next meeting was July 25th, and when the board received the briefing on cannabis on July 11th, they directed staff to come back on the 25th to reconsider the permit options for ordinance amendment, permit options for hoops. I don't know if you were briefed on that. So we returned on July 25th to the board, represented the options that we had presented before, except the first one, which is what they chose the last time, which was the director determination that hoops are not, that they're farm equipment and not structures. So after much discussion, and I would say a cliffhanger vote, the board voted 3-2 to return to the work program item as it was included in our work program to to prepare an ordinance amendment and environmental review associated with that to exempt hoops under 20 feet and to consider permit options for hoops that exceeded 20 feet. So it's a more comprehensive look at permitting of hoops. So we've, I believe, soon after the hearing, issued an RFP for an EIR consultant to come on board and do some environmental review for us. So that was the 25th. And then just a couple of upcoming hearings that I thought your board might be interested in. Next Thursday in Calabasas. I'm not sure why in Calabasas, but that's where the Coastal Commission meeting is being held this month. They will be taking up the Eastern Goleta Valley Community Plan. And their hearing, again, is Thursday, August 10th, and it won't come up before 1:30 because they're doing a site visit in the morning. So if anybody wanted to tune in or attend, that's when that hearing's coming up. The board is out of session for the next few weeks, and they come back on August 22nd. And on August 22nd, they'll be considering whether to submit a permit to retain the emergency revetments at Goleta Beach that were installed earlier this year as a result of storm events, or remove them. And so that will be a big item, not one that's directly in your jurisdiction, but one I thought you might be interested in. And then on August 29th, the board will be hearing the Rancho La Laguna tract map. So things to watch for.
So it's not as sleepy as it might first appear in planning and development.
The next few weeks might seem sleepy to everybody else because there aren't, huge hearings. But we have to do all of our work in advance of those huge hearings, so it doesn't feel too sleepy to us.
Ms. Black, with regard to hoop structures, is the current direction that under 20 feet hoop structures would be exempt throughout the county, or are there particular areas?
Well, Mr. Chair, currently they're not permitted except as greenhouses. So today, hoop structures under 20 feet, over 20 feet are not exempt at all. So what we're looking at is an ordinance amendment to explicitly exempt hoop structures. And I think the board's intention was that they would be exempt under 20 feet throughout the inland area of the county. Certainly in agricultural zones. I'm not suggesting that people could put, acres of hoops on residential properties, but where agricultural land uses are permitted, they would be permitted as well through an exemption.
Well, I would speculate that areas on the south coast would want to be heard on that, perhaps have a different view than areas in the San Ynez Valley and Santa Maria Valleys, which have for a long time used hoop houses as a process, a regular agricultural process. But you will recall the struggle over greenhouse in the Carpinteria Valley.
And Mr. Chair, just to be clear, we are not proposing to address exemptions for hoop houses in the coastal zone.
Okay. All right. Any other comments on the board report? Don't see any. So are we ready then to move on to item 1 on the agenda? Mr. Villalobos.
Thank you, Mr. Chair. The following is a hearing on the request of Berkeley Breathed, appellant, to consider the appeal case number 16 APL 24, application filed on December 1st, 2016, of the director's approval of an as-built temporary access driveway for exploratory well and septic service testing, and to determine that upholding of the appeal and de novo denial of case number 16 LUP 364 are exempt from the provisions of CEQA pursuant to state CEQA guideline section 15270A.
Thank you. Do we have any ex parte communications or site visits to report? Commissioner Brown?
I do. I got a phone call, message actually from Ms. Souter, and I returned a call, but we never connected. I talked to the appellant, Mr. Breathed, and attempted to do a site visit. I drove as far as his home at 810 Toro Canyon, looked over the side, and said, "That's it, I'm going home." Having done lots of site visits where I've sort of been stranded, I felt I'd seen enough, and I thought that was helpful and informative. So that's the extent of my ex parte and site visit.
Thank you. Commissioner St. John's.
I made a site visit yesterday to Mr. Breathitt's property, and while walking the property with him, we discussed mainly the issues that are in the letter that we received on the dais this morning from his attorney. And I also had a call from Cindy Souter, and we discussed some of the history of the issues of the project, and she answered a lot of my questions about the history.
Commissioner Farini, Commissioner Blau.
Yeah, this is Commissioner Blau. Yeah, I had a phone conversation with both the applicant and the appellate. No site visit.
Anything, Commissioner Farini?
No, nothing.
Okay, thank you very much. I had phone calls with Mr. Breathitt and 2 calls with Ms. Souter, and made a site visit this past weekend on foot, fortunately. I got further than Commissioner Brown, but was thwarted in getting all the way to the proposed building site by the debris piled on the pathway. And we'll talk later about the condition of the pathway. So I do have a good idea of where the proposed temporary road would be placed. So I think we're ready to go forward with the staff report. Good morning, Mr. Stewart.
Good morning, Chair, members of the Commission. My name is Sean Stewart, planner in the Development Review Division. The project before you today is the Breathitt appeal of Koch grading for temporary access. The project site is located at 806 and 810 Toro Canyon Road. Here's a closer view of the 2 parcels. As you can see, 806 Toro Canyon Road is located immediately south of 810 Toro Canyon Road. As such, access to 806 requires passage over 810. And regarding ownership, 810 Toro Canyon Road is owned by the appellant, Mr. Breathitt, and 806 Toro Canyon Road is owned by the Koch Trust, but is represented by the applicant, Mr. Sublett. The timeline of events associated with this appeal is as follows. As a result of litigation between the applicant and the appellant, a 2013 settlement agreement was reached between the parties. From the settlement agreement stemmed a 2014 recorded access easement favoring 806 and burdening 810. In October of 2015, the applicant conducted the unpermitted grading and drainage installation. In August of 2016, the applicant submitted land use permit application 16 LUP 364. In September of 2016, the appellant was issued a grading violation for the work done by the applicant on the appellant's property, which included grading in excess of 50 cubic yards, cut slopes in excess of 3 feet, and required a land use permit. The applicant was not issued a violation for the grading done on the 806 parcel because it was not in excess of 50 cubic yards and did not have vertical cuts of 3 feet or greater. In November of 2016, staff conditionally approved 16 LUP 364 in reliance on easement language, which explicitly states the actual location of the easement is subject to the approval of applicable local and state governmental agencies. In December of 2016, the appellant lodged a timely appeal of 16 LUP 364, which immediately stayed the issuance of the land use permit. And in January of 2017, litigation began again between the parties in Santa Barbara Superior Court for various breach of contract claims stemming from the terms of the 2013 settlement agreement. Additionally, both parties seek an order from the court to determine the parties' respective rights related to the settlement agreement. Here's a before and after photo of the area of work The horizontal line spanning the lower 1/3 of the screen is the parcel boundary, which separates the appellant's parcel to the north and the applicant's parcel to the south. The image shown on the screen depicts the easement boundary shown via the red dashed line. An old agricultural road that existed prior to Sublet's grading is shown in yellow, and the as-built driveway is shown in white and surrounded by contour lines. As you can see, the areas of work located outside of the easement boundary included the riprap, the dogleg portion of the driveway, and drainage conduit shown here. Here's another image which demonstrates the areas of work located outside of the easement boundary. Here's the riprap, the dogleg portion, and the drainage conduit. Following the appellant lodging his appeal, staff learned that Breathed's written consent was required for the approval of the land use permit application, given that portions of the grading and drainage installation occurred outside of the recorded easement boundary. The appeal issues raised by the appellant are as follows. The graded driveway constitutes a non-allowed improvement upon a vacant parcel prior to a principally permitted use. The ad hoc driveway has not been evidenced as being within the easement borders. The stockpiling of drainage equipment occurred vastly beyond the easement borders. The illegal, non-permitted grading occurred on property separate from that of the permit applicants in defiance of Santa Barbara County regulations. And the Koch Sublet parcel does not enjoy recorded easement access over the 10 parcels that must be traversed via a private roadway to reach the Breathed parcel from Toro Canyon Road. Regarding appeal issue number 1, staff offers the following analysis for the commission. The approval granted under 16 LUP 364 was a temporary entitlement that allowed use of the as-built driveway to conduct well and septic testing. The entitlement was temporary because it was conditioned such that the area of work would be required to be restored should testing be unsuccessful, and alternatively, if testing were successful, then a follow-up application with plans for a home and a reconstructed road would be required. As such, either subsequent follow-up action by the applicant would resolve the issue of a non-allowed improvement on a vacant parcel prior to a principally permitted use. Regarding appeal issue number 5, since the permit application did not encompass the private roadway that crosses the aforementioned additional properties, this issue is outside the scope of 16 LUP 364 and also therefore outside the scope of this appeal. Section 3580 30B of the County Land Use and Development Code mandates that an application may only be filed by the owner of the subject property or another person with the written consent of the property owner. In the instant case, Mr. Breathed's signature was lacking from the permit application for 16 LUP 364, and portions of the grading and associated drainage devices were located outside the boundaries of the recorded easement. The applicant contends that the settlement agreement constitutes the written consent of Mr. Breathed, but staff disagrees given that the settlement agreement was signed longer than 2.5 years before the application submittal, and also on the basis that the settlement agreement did not consider this specific project. Additionally, the terms of the settlement agreement are currently in dispute between the parties. As such, staff recommends that the Commission uphold the appeal, case number 16 APL 24, make the required findings for the denial of the project, determine that the denial is exempt from CEQA pursuant to section 15270, projects which are disapproved, and deny the project de novo, case number 16 LUP 364. And this concludes my presentation. Staff is available to answer any questions.
Any questions for Mr. Stewart from any commissioners? Anything from Commissioners Blau or Farini?
No, sir, not right now.
Okay. Oh, I think there are a few questions, Mr. Stewart, but it might be answered in the various presentations we're going to hear. So let's proceed with those, and we can come back and resolve any unanswered questions. So this is an appeal. We'll hear first from the appellant, then from the applicant, and we'll give both parties the opportunity for brief rebuttal, provided they reserve time up front. So let's hear first from the appellant.
Good morning, Mr. Chair.
Mr.
Excuse
Chair,
me just a minute.
If I
Yes.
could just ask for clarification, so how much time are you giving the
We're
parties?
going to ask how much
Oh,
time
okay.
is needed. I'm with you on that one.
Good morning. Good morning. My name is Mark Carney, and in answer to the first question, I think that it will take about 15 minutes for me to make my presentation, but I would like to have an additional perhaps 5 or 10 minutes for rebuttal, depending on how lengthy the presentation is.
Well, given the fact that this is the only item the commission's dealing with today, I think we can be generous with our time. That's a little more than we normally allow, but let's go with 15 minutes initially, and if you don't use it, 5 more you can reserve for rebuttal.
Thank you, Mr. Chair. I'll do my best. Mr. Chair and members of the Commission, my name is Mark Carney. I'm an attorney with a law firm of Liebersbach, Moen, Carney & Reed. It's a law firm that was founded in Mammoth Lakes, California in 1996. And 9 years ago, we opened up an office in Santa Barbara to accommodate my decision with my wife to relocate my family here and raise our family here. So I am pleased to have the opportunity to address you on behalf of Appellant Berkeley Breathed this morning. Mr. Breathed joins us here this morning. Mr. Breathed and I are both very appreciative of the contributions that your planning staff and council have made to this effort in order to get it right. All of the county employees with whom we have communicated in connection with this effort have treated us with the utmost fairness and professionalism throughout, and we appreciate that, particularly because it's an unusual circumstance that the department finds itself in. I think it's probably very rare that we find themselves in a position where they're recommending that the Planning Commission accept an appeal, withhold an appeal of the director's own decision. And we recognize that that recommendation demonstrates a high degree of integrity in the people who made that recommendation in the process itself. So we appreciate that. But frankly, it's not really surprising to us that the staff did approve the original application, because in the application, Mr. Sublett and his consultants didn't tell the whole story, didn't provide the whole truth to the staff. And we're confident that if Mr. Sublett had provided the whole truth to the staff from the beginning, this appeal would not have been necessary, because the decision would have been made to deny the application from the outset. For example, Mr. Sublett did not reveal that the actual location of the easement at that time had not been defined, and still to this day has not been defined. The easement agreement itself says the actual location of the easement will be approved by the county. There has been no effort whatsoever by Mr. Sublett to nail down that easement within that easement area to this day. Nor did Mr. Sublett or his consultants reveal that the settlement agreement requires that the design and location of any proposed road must be approved by the county. Now, the word proposed is important here. We don't need to all run to our dictionaries to understand what that means. We know what proposed means, and we know what it doesn't mean. And it doesn't mean that you build a road and then you ask for permission. It means you bring plans to the county, and you go through those plans and you define what the design and location of the easement is going to be and where the road is going to be within that easement. That didn't happen. And therefore, the staff was left to believe that Mr. Sublett did in fact have permission to do what he did, because he said he had an easement to do what he did. In fact, there's more to the story, as you now well know. But once the staff did learn the truth, once it did learn what was going on, it immediately set out to do the right thing. And the staff correctly identified that the permit application required Mr. Breathitt's signature, but did not have his signature. And there was no other evidence of any consent, certainly not any written consent from Mr. Breathitt with respect to the application. And therefore, the staff made the correct decision to change its course and to recommend to you that you uphold the appeal based on the fact that there was no written consent by Mr. Breathitt to the application. Now, counsel for Mr. Sublett has written a letter that's in your file that basically says, oh, that's not true. It's not true. Mr. Sublett did get Mr. Breathitt's permission. He got written consent, and they point to the settlement agreement in order to provide evidence for that written consent. And by the way, he's not arguing, of course, that there was any consent on the application itself, just that approximately 3 years earlier, consent was given related to the settlement agreement. Now, if we set back 3 years earlier from now, we see what happened. There was litigation over this issue. And what Mr. Breathitt decided to do is he wanted to end the litigation, and he was going to allow Mr. Sublett to access his property over an easement so he could get to 806. But he put protocols in place to make sure that got done right. And that was the purpose of the easement agreement, stating that the county needed to approve that location. That was the purpose of the settlement agreement, saying that the design and location of the road must be approved by the county. That meant, from Mr. Breathitt's perspective, that it was going to get done right, that it was going to comply with the LUDC, that it was going to comply with CEQA, and that when all was said and done, there would be a road there, yes, but it would be a proper road, an approved road, a road that didn't impact the environment negatively. So Mr. Sublett quotes a provision in the settlement agreement which states that Mr. Breathitt, on behalf of himself and future owners of the 810 parcel, will consent to and support the applications. The problem that Mr. Sublett has in this regard is he never submitted the applications. The applications was a defined term in the settlement agreement with a capital A, and it was applications for a proposed road, which means before you build the road, you propose the road in the application, you propose the design, you propose the location, then you get it approved, and then Mr. Breathitt's responsibility to consent is invoked, and not before. But that's not what happened. Mr. Sublett didn't get the consent prior to building this road, and he still hasn't gotten the consent from the county to approve the easement or the design and location of the road. Instead, if I can direct your attention to the screen, this is what Mr. Breathitt got in response to his efforts to get a proper road built. This is an aerial view of the road looking from the south to the north. You can see the whitened portion of this road on the bottom of the screen was existing prior to Mr. Sublett's trespass and vandalism. And the part of the road that he built is the section that goes from that to the north. In the next screen, we see a representation of what the hillside looked like when Mr. Breathitt signed the settlement agreement. Now here's a picture of what it looks like today. The before and the after. From another angle, a depiction of what the before situation was, a picture of the after. This now, of course, is looking from the south to the north, whereas the prior one was looking from the north to the south. Again, a picture depicting a representation depicting the before status, and a representation depicting the current status. Excuse me, a picture depicting the current status. This is the problem. When you don't go through proper planning procedures, when you don't get the county involved, when you don't involve CEQA, when you don't get it approved before you build it, this is what happens. I'm not an engineer, but it looks like there's a retaining wall that would be necessary there. But the problem with retaining walls is they're expensive. They take time. You've got to go through a lot of process to get there. You've got to really be intent on getting it done right, and then you have to pay for the retaining walls. But if you're anxious to get a well permit, if you're anxious to try to get your property sold, you might be tempted, depending on your ethics, to skip this step, to forge forward, or as Mr. Sublett likes to call it, to pioneer this road. Now, I did look up that word, and apparently what it means is going ahead and building on another person's property without authority or permission, because that's all I can understand that it means. So in his legal documents, he says he pioneered this road. In his counsel's letter, they pioneered this road. What that means is code for we did it without permission, and we did it on someone else's property. And they did this. Imagine when you sign a settlement agreement of a litigation that was supposed to ensure that you had a proper road built with proper standards which was going to protect the impacts to the environment, that you walk out of your house after not having been at the house for several weeks and you find this. You find tons of construction debris spread down a hillside that you own. This is what happens when you try to jump the gun and avoid the responsibility to get the road approved first. So, this was done. This was removed from the site by Mr. Breathitt. This is just some of the debris that Mr. Breathitt was required to remove from his property in order to reclaim his property and protect it from this invasion. So that's the status of the road right now. Now, Mr. Sublett's attorneys will argue that, again, the consent was in the settlement agreement. The settlement agreement specifically says that Mr. Sublett will seek approval from the appropriate local and state agencies regarding the proposed location and design of the roadway described in the easement. And applications is defined, as I mentioned earlier, with a capital A. And that is what Mr. Breathitt agreed to consent to. If he filed the applications properly and he got approval from the county, then of course Mr. Breathitt was going to consent to it. But that's not what happened. Now, since Mr. Breathitt did not sign the application, since no reasonable person would come to the conclusion that what I just described evidences Mr. Breathitt's consent, Mr. Sublett's attorneys have tried to find other ways, other indicia of consent that Mr. Breathitt may be responsible for. And in the letter from counsel, they specifically discussed two matters. By the way, none of these have anything to do with written consent. But they're left to say, oh, even though it wasn't written consent, he consented by either his actions or his inactions. And in particular, counsel points to a meeting on site on August 26, 2017, among Mr. Stewart, Ms. Souter, and Mr. Breathitt. And apparently at that meeting, at least the way it's been discussed by counsel for Mr. Sublett, Mr. Stewart asked the question whether this is where he wanted the access road to be placed, right? And Mr. Breathitt wisely did not respond because it didn't make any sense. The road was already there. It had been there for 8 months, and now he's going to ask if this is where you want it? That was supposed to happen many months before. And what does counsel for Mr. Sublett conclude by Mr. Sublett not saying anything? That his refusal to object was tantamount to acquiescence. It meant he agreed. And then he says, relying on Mr. Breathitt's refusal to object, and in order to minimize Mr. Breathitt's view of the access road, Mr. Sublett pioneered the temporary road over a few days in October 2015. Well, wait a minute, this meeting happened in August of 2016, and from that meeting, he supposedly learned information that he relied on a year earlier? That makes no sense. The meeting happened after the grading had been done. So how could Mr. Sublett have been relied on what wasn't said in that meeting to justify the actions that he took in October 2015? It's nonsensical. The next thing that Mr. Sublett claims evidences consent is that after Mr. Sublett did all this, Mr. Breathitt did nothing to object to it. Well, that's patently untrue. That's just false. Mr. Breathitt wrote letters and texts to Mr. Sublett and his consultants objecting to what had happened. He contacted county officials. He hired an attorney. He removed the drainage improvements. He appealed the decision, and he filed a cross-complaint in the Superior Court. And that's what Mr. Sublett's attorney wants you to believe is consent to signing the application, because he didn't object. That is also nonsensical. So what we're left with is there was no written consent by Mr. Breathitt. The staff got it exactly right. Mr. Breathitt's signature had to be on that application, or there had to be some example of written consent, or the application was flawed because it didn't have the name of the property owner attached to it. Thank you for your time, and I'm happy to answer any questions you may have.
Any questions of council? Not seeing any, Mr. Carney, for right now.
Thank you, Mr. Chair.
Don't go far. All right. We'll hear now from the applicant, Mr. Sublett, and his counsel. Just before you start, I'm proposing 15 minutes, 20 minutes total, any way you want to use them. If you want to reserve, though, let us know, and we'll give you whatever of that 20 minutes you haven't used originally.
Thank you. That's fine. I hope to be less than 15 minutes and certainly less than 20 minutes overall, but I would like some rebuttal depending on Mr. Breathitt's counsel's rebuttal. Good morning, Mr. Chair and ladies and gentlemen of the Commission. My name is Benjamin Pugh. I represent Brad Sublett, the applicant for this permit, and I want to focus on the, well, I have a few things that should go pretty quickly. First, I want to focus on the staff report's reason for not considering the settlement agreement as counting for the approval of the landowner. The reasons that were given were that the settlement was 2.5 years old. It didn't envision this particular project, and that the parties are suing each other respectively to enforce the settlement agreement. The first reason I can't see why that's relevant at all, the time between the execution of the settlement agreement and today. It's not been revoked. It's not been declared invalid. No one is suing in either of the complaint or cross-complaint to declare it invalid. It's fully enforceable. So the mere passage of time is not relevant. The second thing that it did not envision this project, well, I do want to very much reiterate Mr. Carney's presentation and description of the help of the staff. We've been in communication with the staff throughout this time, and they've been nothing but very professional and very helpful. But I disagree with this. The settlement agreement, the entire point of it was for this very project, was to place a road over the easement area, which staff has correctly concluded is undefined. And that's because we all knew, and everybody knew before signing the settlement agreement, that there would need to be a process of approval by this board and various stages of approvals. We're here at the very first stage. I want to emphasize this is a temporary permit request. And the staff report was entirely correct that if this is the well and septic tank, or the well and septic testing is not successful, the condition of the permit is to restore the property to its prior status. The well and septic testing, I'm informed, will take a couple of weeks. So all we're asking for is permission to drive a few trucks across the existing roadway, do the testing, and we'll be done. The vast majority of all of the other issues that Mr. Breathlett has raised can and will be addressed in a subsequent permit application for a permanent road. The next thing I want to address is the various, the picture that's up on the screen. First, that rubble, that, as far as I know, was all placed there by Mr. Breathlett. It was ripped out and dumped on the road by Mr. Breathlett, not us. This is not how we left the road. I also believe that's not even on Mr. Breathett's property. That is dumped on the 806 parcel. And the retaining wall, the slight tears, that may be the way it is today, but that's because this has been taking a long time, and Mr. Breathlett has erected 2 poles preventing my client from accessing that roadway in any way to do any maintenance. I just want to briefly discuss what that equipment is and the riprap. And it's just basic easement law that when something is granted for your use, what is also granted is anything required for you to use that. Obviously, you're going to have some sort of drainage so a road doesn't wash off. The easement itself contemplates planting trees and other brush outside the easement area to block the view of the road and potentially the residents from the view of Mr. Breathett's residence. So that's already in the easement that it is allowed to go off of the specific roadway in order to maintain the purposes of the easement. But all of the geological problems that Mr. Carney and Mr. Breathlett are claiming, those, the county has been involved in this, has made site visits, and the initial approval approved the work that was done. There were no geological problems, there were no grading problems with the stability of the road. No one noted any of those. And even today, the only issue, the only reason staff is recommending that this permit be denied and the appeal upheld is that Mr. Breathlett won't consent. And the only reason he can possibly give to not consent is because the path goes further down the hillside, further away from his house, less in view, along an existing agricultural road path, along a path that would require substantially less grading and disruption to the environment. So what we haven't seen yet, what we haven't heard yet, is any actual objection from Mr. Breathlett to the path that we have proposed in this easement. We've heard him say that it's not on the path that the parties estimated in the easement, but everybody knows and everybody's agreed that we would make an application to set forth, or to this body, to set forth the final path of the road. And if Mr. Breathlett objects to that path, which he may, he has remedies in the settlement agreement. He has not objected to that path. And I submit he has not, because if he does, it'll be in bad faith breach of the settlement agreement, because there's no good reason whatsoever to object to the path that the road was cleared, as opposed to going further up into the hillside, closer to Mr. Breathett's property, completing more grading. So Mr. Breathlett insists that happens. We can make that happen, but the easement built in that flexibility. and the ultimate approval comes from this body. That is what the settlement agreement says. And it's very important that that settlement agreement is not just a contract, it's not just a piece of paper that he signed consenting some time ago. That was a settlement of a specific lawsuit. That settlement's enforceable in court under Code of Civil Procedure 664.6. It's the essential equivalent of a court order. Mr. Breathed cannot revoke his consent without further court process, which he has not done. So unless and until he does that, he has consented. The settlement agreement gives this body the right to approve the specific path. We've proposed a path that is eminently reasonable, that staff had approved for all intents and purposes other than the mere lack of Mr. Breathed's consent, which, given the settlement agreement's language, he hasn't revoked. He did grant. I respectfully disagree with the staff's reasons why the settlement agreement doesn't count for the consent. And if this commission finds that the settlement agreement does amount to that consent, then there's no other reason to affirm the appeal. Thank you very much.
Mr. Pugh, just one question. The contention was made by Mr. Breathed's counsel that the settlement agreement required the county to approve. And you're not, it appears, disputing that. You're just indicating the county did approve at one point the location of the easement.
The county did at one point approve the location of the easement. Where we differ on the settlement agreement is the notion that before my client could pluck a blade of grass off of the easement, walk along there and tread down foliage. Now, obviously what he did was more extensive than that, but the same logic would apply. He had to get an approval from this commission for the specific path. That is just not the way the settlement agreement reads. They keep saying that it's you have to get an approval before you do anything. Well, we haven't built a road. We've just cleared an existing agricultural road, and that's what the first, actually it's page, in the staff report, in the 4.0 section issue summary, in the second paragraph, acknowledges that what was cleared was an existing agricultural road. So, before traversing the road to do the well or septic testing, we are here getting or seeking the permit, but this is the permit process.
Okay, so just following up on that, you're saying that the whole process of grading the road initially, putting in the drainage pipes, taking steps to make sure the road didn't slide down the hill, this was all permitted prior to getting any approval of the county?
I am not disputing the citations that it was unpermitted. What I am saying, though, is that the permit application was granted essentially absolving the de minimis work. It really was de minimis. It's not a substantial amount of grading. It exceeded, from my understanding, the 50 cubic yard level, but it would have been, proper to get a grading permit before that. But when the county issued the permit saying, we understand you jumped the gun on these particular things, but it's fine because we looked at the work and we would have approved it anyway, that was blessed. And again, Mr. Breathed hasn't given any evidence here that there's anything, again, geologically or structurally wrong with the road. He's only arguing about the path and that he needs to approve the path. And that's why we're here. We're here to ask you, is the path okay? And the path, and we've heard nothing from Mr. Breathed as to why the path is not okay.
Okay, thank you.
Thank you.
All right, rebuttal. Mr.
Thank you,
Carney.
Mr. Chair. I will be brief, Mr. Chair, because I think that you've zeroed in exactly on the issue, and I think you've got it very clearly in mind, that what we're talking about is what Mr. Sublett did before he applied for any grading or land use permit to the county. This screen shows you what he did. Now, Mr. Pugh wants to minimize that, as if Mr. Breath had said, oh, you're not allowed to walk in your easement area. If you touch any blade of grass, that will be a violation. Well, that's absurd. He has an easement. He can walk over it. What he can't do is build a road, not a path. He can't build this road without the county approval, and he did that, and he's admitted that he did that. And so the more you zero in on that question, Mr. Chair and members of the Planning Commission, did you get prior approval of that road before you built that road? The more clearly in focus the proper path for you to take today is. And clearly, there was no approval by the county for that road, and therefore we ask you to uphold the appeal. Thank you for your time.
Thank you, Mr. Carney. Any last questions? I don't see any. Thank you. Before I call you back, Mr. Pugh, I see Ms. Suter has offered to speak to answer questions from the commission. Would you like to wait until she has a chance to do that before you finish your rebuttal?
I'm only going to rebut to what Mr. Carney just said for about 10 seconds.
Oh, fine. Let's do that.
Yes, Mr. Sublett did not get approval to put that, to clear that existing road path before. But again, the county blessed that action after the fact when it issued the permit in the first place, finding nothing problematic with it after it went out on a site visit and viewed it. So that's not a reason in the staff report why the permit should be denied. It's just Mr. Breathed's objection to the path. And I would point out that what we're seeing right there is very much on the path. There's only a short, further on down is where it cuts in further inside and away from the hillside. So what you're looking at right now is the path that Mr. Breathed agreed to.
Hold on just one second. I have a factual question that I'd like your opinion on. It looked like from the photos we saw earlier that what Mr. Sublett graded was entirely new from the existing cement portion of the access road to his property, and that he wasn't simply improving an existing path. It was a totally different cut. If that's not accurate, I'd appreciate you straightening us out on that.
No, it's not. And what you can see, I believe it's Exhibit E to the staff report. There are two pictures, one on top of the other. And on the top picture, you can see it's dark. It's not light because there's foliage over it, but that's primarily the path that the path below travels. And this little cut, which is a little darker than the one that goes up higher, that's the path that they followed. So there were paths there.
Let's just make sure we're looking at the same thing. You're talking about photo 2 in our staff report?
It's called Attachment E.
Okay. Let's see. Okay, I think I can see what you're saying. I just was confused about whether it was an existing roadway or whether it was an improved roadway by Mr. Sublett.
It was a very old existing roadway that had been grown over.
Okay, thank you. Mr. Carney.
Thank you, Mr. Chair. That's just not true. That was a condition of this was the, everything that you see there is new. Everything that you see from that concrete to the Cook property is new. That was a road that was graded and built. Let's not miss that point at all. This was not an existing road. When they came to the application stage, they called it an existing road, but they neglected to mention that it's existing because only months earlier they built it without the county's approval, and they called it existing.
What about this? Was that pre-existing, the road cut?
That is a path that does not go down to the easement property.
Well, hold on, Mr. B. That you can't testify from there. So
what Mr. Breathitt is saying is that is a path that does not access 806. That is a path that goes into the other direction, and that is not obviously encompassed by that roadway. That is separate and apart from the roadway that was graded above it. The road that was graded above it is clearly shown as much wider than that little walking pathway below it.
I understand that. I'm just trying to get a definition of what that appears to be as a pathway down below, and can you tell us that that's just a walking path that pre-existed the grading, the initial grading?
Yes, sir.
Okay, that's good for now. Ms. Suter.
Good morning, Mr. Chair, members of the commission. I think I just need to offer some clarification because what this road is, well, first of all, the property is just riddled with old trails and old ag roads and old bike trails and SUV trails, or not SUV, ATV trails. So there's a lot of old paths on this property. But I just want to clarify, if you look at your attachment F, it's probably the most clear way to see it. Can you switch it to the Dan John survey one? Yeah. Okay, so the yellow on this exhibit, this is a as-built survey of the road as prepared by Dan Johns after construction. So this is real life where it is. And Dan Johns is a licensed surveyor. So the yellow road is the old existing agricultural road on the property. The one that Chair Cooney was asking about in the other picture that kind of went down, that's the most right-hand side of that. And then it comes up and joins with the existing road that was used for the access to 806. So the part of the road that you see in white that is outlined by the red meets and bounds easement legal description, which the easement's kind of strange because it's got a meets and bounds, but then there's this wiggle room caveat, for lack of a better term, in the actual easement document. So for the meets and bounds part of the easement is that red dash line. So you can see where the white part of the road is, that was new construction. And then actually the little, on the right side of the yellow line. And then the little part that's in between the notch in the yellow, that was another old roadbed that they found. Just below that.
This?
Where that little triangle is, yeah.
Okay.
That was when they were clearing to grade in the road, they found another old path, and so they used that rather than going up to the higher location, not the yellow, but the red dash line, to keep the road lower and use existing graded areas. Does that clarify it for your commission, the difference between what was existing and the actual section of new construction?
I'm not sure clear is the word to use, but it gives further information. Thank you.
Okay.
Thank you, Ms. Sutter. All right, so that concludes the presentations of the parties. I want to ask if there are any other public speakers on this matter. Do we have any slips, Commissioner Brown? Okay, then we'll close the public testimony portion and bring it back to staff. I just asked for members of the public. Are you want to address the commission, sir? Yeah, have you filled out a speaker slip? Okay, well, if you're willing to do that for us afterwards, come on up.
Good morning, Mr. Commissioner, Mr. Chairman, fellow commissioners. This isn't my normal role or activity. My name is Al Gels. I'm a real estate broker. I've been licensed in California since 2004, and I've been involved with this property with the Coach family, which is the legal fee owner of the property, and with Mr. Sublett, who has a realty interest in this property through his contract with the Koch family, going back to 2009 when we first listed this property for sale. Conrad Rietveld is a partner of mine. He's now deceased, but together we worked and represented the Koch family to sell this property, which was part of their estate. So when Mr. Brethid, so we listed this property in 2009. Mr. Sublett purchased the property in 2013. So there were 4 years that this property was on the market, and during which time it was obviously difficult to sell. It may have been mispriced, but one of the big deterrents was having legal access through 810 Toro Canyon Road. And it was certainly, on a number of occasions, it was reported back to us by prospective buyers that Mr. Brethid had met them, talked to prospective buyers, and really dissuaded them from entering into any type of transaction. And it became apparent to us that it was his, because he had a superior or a view up the road, he was treating this property more or less as his private preserve and parkland. And he and his former wife had been presented the property, and they chose not to buy it, but that didn't preclude him from constructing a dirt bike track on the Koch property going back to 2011. And I've got some examples of how that dirt bike was constructed with improperly permitted roads, grading, brush thrown off the edge. And it was only after signs were posted, no trespassing, that it seemed like activity ceased. Now, during that period of time, I often visited the property probably once or twice a year. I reside in Orange County, so I wasn't here locally. And so after that, once it was learned that Mr. Sublett had entered into a contract to purchase the property in 2013, the litigation that resulted was actually a preemptive lawsuit by Mr. Brethid trying to scare Mr. Sublett away from continuing in his purchase or acquisition of the property. And so the past behavior of him trying to, scare people away from buying and using this property seemed to continue on. And it was only because of the settlement of this lawsuit, and he really didn't have, the result of the settlement was that they weren't going to fight each other, but two, that an easement would be granted through 810 Toro Canyon Road. That was the settlement, and that allowed Mr. Sublett to go forward with his contract. The contract was contingent upon him acquiring an easement through the Sublett through the Brethid property, which then, once that easement was acquired, then Mr. Sublett went forward with his contract with the Koch family. So,
could you just wrap up?
So, the long and the short of it is, Mr. Brethid has treated this property like his own park. He's used it for his own convenience. He's denied Mr. Brethid his quiet use and enjoyment of the property, and gone so far as to obstruct his access to the property after it had already been legally granted. And so it seemed to me that the process by which we're now debating of whether or not a consent was signed, it had previously been granted through an easement which runs with the property in perpetuity, and we're just kind of arguing about punctuation points here rather than the facts that are really on the table, and that is, no matter what Mr. Sublett does, Mr. Breathitt is not going to be happy with the development of the site of the property below him. Period.
Thank you.
Thank you very much for your time.
Would you fill out a speaker slip, please, Mr. Gels? Thank you. Anyone else? Okay, now we'll close the public portion of the hearing, come back to Mr. Stewart. Anything you have to add or clarify?
Nothing additional at this time.
I have a question about when the land use permit was under review by you. Did you have a chance at that time to look at the site and see the graded road? Do you have any clarification about the testimony we've heard as to what it looked like?
Chair Cooney, members of the commission, once the land use permit application was submitted, I did conduct a site visit. I would agree thus far with the testimony as far as the description of the grading that was conducted, the as-built, or the the existing agricultural road that was just demonstrated in the site survey. I believe, as described, you've received an accurate description.
Okay. Did you ever look at the easement description or have someone explain to you how the graded road departed from the location as the easement described?
Chair Cooney, members of the commission, I did review the grant of easement. I see that it was described in meets and bounds, and that also that prior to my approval of the land use permit, we received the as-built site survey from Cindy Souter, which demonstrated the areas where the as-built deviated from the recorded meets and bounds. And in my approval of the land use permit, staff relied on that language, which states that the actual location of the easement is subject to applicable state and local government agencies.
So you saw that as part of what you were being asked to do, was locate that easement?
That is correct.
Okay. Anything else for Mr. Stewart? Any questions from Commissioner Blau, Commissioner Freeney?
Yes, I have one, maybe a couple. Typically, when you make an application for a grading permit to put that road in, it would be an engineered road. I mean, you'd have grading plans, you'd have requirements for retaining walls, for drainage devices, and so forth. Has that been completed, or is that yet to be done?
Commissioner Blau, Chair Cooney, the engineering of the road has yet to be done. There were no engineered plans submitted with the land use permit application.
Mr. Chair, Commissioners, I would add that this was represented as a temporary road for access to testing only, so we didn't expect the retaining walls. At this point, we would have expected them upon submittal of an application for a permanent road with a principally permitted use on 806 as well.
Okay. Yeah, anything further, Commissioner Blau?
Well, I'm not sure this is deliberations or a question, but are all the issues that you would normally look at for a temporary road had the applicant done it correctly, where we got the application approved before we moved 50 cubic yards of dirt? Are there any conditions or anything that might have been different had you done it properly, as opposed to going out and constructing road and asking for permission later?
Mr. Chair, Commissioners, I've got to say that we were simply presented with an as-built situation. We knew there was a violation. We knew that the applicant wanted to do septic testing and well testing. In order to resolve the violation, we said, all right, it's a temporary road, restore it if you don't get testing positive on the well and septic, and we moved forward. It was not the normal course of events.
What it appears to me is different about this case than the typical temporary road for testing case is that the roadway itself, the temporary road graded without any permit or knowledge to the county, was on someone else's land. And it's one thing if you're going across your own land to create a road very primitive, and as long as it doesn't look like a health and safety matter, allow temporary testing there. And I've seen that throughout my neighborhood. But this is the first instance where I've seen it, the grading and the premature grading, which was sought to be approved subsequently, was on someone else's land. And I don't know if that's your experience or whether this was unusual for that particular issue, but it seems to underlie what you're asking for now, which is to have the commission overrule the permit based on the fact that the landowner of this graded road was not a party to the application. Do I have that correct, Ms.
Mr. Chair, you have that correct.
Okay. All right. Anything further of staff before we move to deliberations?
Yeah. Yeah, I have a question for Mr. Stewart. Attachment J is a letter saying that there is no access, or they're denying access. Can you help me with that? So they can go through Breathitt's property, but they can't go through the other properties. So how do they get there then?
Commissioner Farini, Chair Cooney, attachment J, the letter from Los Alisos Ranch. To give you some background, Los Alisos Ranch is a neighboring property to both the 806 and 810 parcels. It is located immediately to the west, and it is understood that access to the 806 parcel had at some point in time been taken through Los Alisos Ranch, and this letter is directing that no longer occur to the 806 parcel.
So it was a different access and not really related to the access they're taking now through 810.
Commissioner Farini, Chair Cooney, that is correct.
Okay, great. Thank you.
And for clarification, Mr. Stewart, I think you indicated the Los Alisos Ranch was to the west. I think it's to the east of the subject property. It's on the next hill over.
I misunderstood.
Okay. It's not that important. All right, I think we're ready to go to deliberations. Let me ask Commissioner St. John, you had questions of staff?
I had two. Could you clarify the signature on attachment J? It says Miller Sublet. Are you aware of the relationship of the applicant to the Los Alisos Ranch?
Commissioner St. John, Chair Cooney, based on the last name of the signature here, as well as in my correspondence with counsel for Sublet, I came across an email signature from the applicant, Brad Sublet, and I believe in his email signature it stated that he was the ranch manager or some type of operations manager associated with Los Alisos Ranch.
Anything further?
Could we get a clarification from the applicant?
Well, I'm not sure. I'm not sure what the relevance is in terms of this letter, which is dated December 15. I mean, we could find out if Mr. Sublette, the applicant, is related to the writer of this letter, but I'm not sure what it has to do with our current deliberation.
Okay, it was just confusing if access was being denied through another parcel. I'll move on to my other question, which is for staff, if under a normal application for a road, temporary road to do the water well tests and the soil testing on a parcel, would drainage culverts and riprap and things like that be part of what you would expect or require, or I'm not familiar with temporary roads.
Mr. Chair, Commissioner St. John, the drainage structures do imply sort of a longer lasting intent on the part of the construction of the road. Temporary road to be used for a couple of weeks typically wouldn't have drainage facilities and riprap, but this is what we were presented with.
Thank you.
Okay, so I think we're ready to deliberate. This is a first district item, and so what I'd like to do is just set a couple of parameters that I've concluded apply, and then hear the thoughts of my fellow commissioners, and then I'll add mine at the end. It's difficult when matter before this commission is intertwined so closely with litigation across the street in Superior Court, even following what came first and complaints and cross complaints and the current status of that litigation. It's all very interesting, particularly if you have a legal background, but our task, I think, is to extricate this permit issue before us today from all the litigation. The parties have every right to continue with their litigation, and regardless of that, we have to take action today on this permit appeal, and if the parties later on agree to a different conclusion, they're free to get a new permit from the county that matches their agreement. But right now we have a permit issue, and as far as I can see, the only part of the litigation that we need to make reference to is the settlement agreement language sufficient to substitute for the signature of Mr. Breathitt on the land use application. It's a fairly narrow issue, and I think that's what we have to decide. If we decide that it does not constitute consent, does not substitute for his signing the application, then we uphold the appeal. If we believe, as does Mr. Sublette and his counsel, that that is adequate consent for all purposes before the county, then we have a basis at least for upholding the permit that was issued by staff. So who wants to go first among my fellow commissioners? How about you, Commissioner Blau? You're always ready.
Yeah, I'm always ready. I guess my problem is in reading the agreement was there was still some opportunity for the appellant to object to the location of the road, how the road may have been built, He certainly could have complained to the director about the conditions that were set, and that might be modified. So I have a real problem with us deciding where that road's going to be when it's not fully engineered and fully approved by the county, and giving the appellant the opportunity to object and maybe cause a modification. So that was my first concern when I read this. I mean, I realize they have an agreement to agree, but there has to be an opportunity to have agreement without having the fully designed road and the approval of the county. I don't see where that could occur. My initial thought was, this just, like Mr. Cooney, continue it until they resolve the litigation, but given the fact it was kind of done so backwards, I'm probably inclined to grant the appeal, let them go do their litigation, and take the proper steps to locate the road. I'll also say that I don't understand the idea of the temporary road with not going through the process of determining the location as to be approved by the county. It's kind of like, why would you allow someone to do a temporary road in a location that could be substantially different than where the permanent road's going to be located? It would seem to me you would nail down the location of the permanent road. Yeah, I might not fully construct it because I don't want to fully construct it not knowing that the property perks and I have a water well. But to me, it's just they haven't taken the right steps in the right order, and so I kind of tend to agree with the appellant that they need to step back and do the things that the agreement requires, get all the necessary approvals for the location of the permanent road, and then I think it could go forward there, assuming that a party it prevails in the litigation and doesn't change the location.
Commissioner Freeney, are you ready?
I don't know if I'm ready like Commissioner Blau was ready. This is a tough one. As you've told us in the past, Chair Cooney, we're coming out into a neighborhood and having to referee the neighbors, and I'm never comfortable doing that. What I haven't really heard is what compels the parties to come together to agree where it is, and timelines, and is time of the essence. And it really does sound like a legal decision. I can't imagine, though, if it was my property and you did have an easement, that you could just come in without us having full agreement on you bringing equipment onto my land. So I think I can rest it there, where I would side with the appellant on this. And I don't think the process was smooth, and I don't think it just doesn't seem like they followed all the protocols that they could have. So I would be in favor of upholding the appeal.
Thank you. Commissioner St. John.
I'm inclined to support the staff recommendation and uphold the appeal on the basis that the language in the settlement agreement it could be construed as an agreement to agree, but there is a reasonable expectation that a person will be asked for their consent when one of these appears in a contract. I do a lot of legal work writing contracts, and my intention always when I'm writing a clause like this is that the person who agrees they will give their consent is expecting to be asked. So to me that's, and also that there is a reasonable expectation that the parties will act in good faith and the person would ask before just starting the construction, and to get the permit before, which it appears that was their intention in the settlement agreement, to apply for the permit and then go through the process.
Thanks. Commissioner Brown.
Okay. Well, I agree with the majority of the commission. I think upholding the appeal is for me what I consider appropriate. I just feel the applicant overstepped his boundaries of what he should have done and what he was allowed to do, or what he did do, and what he was allowed to do. So that's basically all I have to say.
Well, thank you all. I agree with you. We have a narrow issue, and that was, should the appellant been a part of the land use permit application? There's a bigger issue I think we need to keep in mind, and I have no doubt that our staff has this in mind, and that is that even as temporary as a road carved out of an undeveloped hillside for testing purposes to determine if there's availability of septic and water, really needs close scrutiny in this, particularly in the Toro Canyon area, where it's a lot like it was 500 years ago in parts, and certainly in this part. When I approached the graded road this last weekend, there was practically no path at all. It was overgrown with weeds. Given another 5 or 10 years, you wouldn't know where it was. It's amazing how nature reclaims what we attempt to carve out of these hillsides. But the issue you present to us and recommend we take is simple to me, in that the applicant did not take the step of getting his neighbor and opposing litigant to sign the permit. And if the applicant had simply taken the step of advising staff, I can't get my neighbor to sign this, he refuses to sign it, you might have a different result. You might not be recommending that we send them back to the starting line. And it may be the case you face going forward. You may not have the ability to get Mr. Breathed to sign the application for a new permit. That's a bridge yet to cross, and I hope the parties can come to some understanding so staff is not left with the inability to process another application. That's for another day. The larger issue I see is coming to grips with this very difficult issue of how much time does staff take to review something as temporary as a permit for access. Certainly, I think it's different when it's over someone else's property. You're going to be sensitive to the fact that we don't have this neighbor participating in the process, and call that out. But generally, I think it is worthwhile, and in recent litigation I've discussed with county council, give some guidance as to how much discretion you have to condition land use permits in general. This is as much a land use permit as ultimately would be issued to build the house, with the access. And all the time we see permits for residential construction with a great deal of time and effort put into conditioning to make sure neighbors are satisfied, to make sure all of the issues we care about in terms of the nature, the effect on nature, are looked at. We don't do it, in my view, soon enough. And I think that's an ongoing review that the department needs to take in consultation with county council. But in this case, certainly, we're looking at the side of a hill. We constantly have the fear of erosion. There are lots of impacts to even a temporary road, and I think we need to be particularly careful when we're approving access across a steep hillside like this. So I had the chance and the time to give this a lot of thought. I totally agree with staff that we can't de novo approve this existing road. So we will uphold the appeal if we vote, as has been indicated by the commissioners, and we'll let the parties start over again with their access, and hopefully that happens in the context of a global settlement of their litigation. So, Mr. Villalobos, if you wouldn't mind.
Commissioner Cooney, could I ask one more question?
Oh, yes, sure. Commissioner Blau, sorry.
Thank you. We got this letter from Mr. Carney, and I'm curious to know if it was received before 1 o'clock on Monday. I noticed it's dated August 1st, and I didn't get an email from Mr. Villalobos till this morning.
Commissioner Blau, members of the commission, so that letter was received yesterday afternoon, and that's when I distributed it. So to answer your first question, no, it was not received by the deadline. To include it as part of your record, the commission will need to vote that in.
Okay, great, thank you. And let me, I would like to ask, I've asked Commissioner Farini, so I'd like to ask the three of you in South County, have you all had a chance to read that letter? And the reason I ask that question, if you've read the letter, for the first time in 11 years, I'm going to vote to include it in the record because it was a short day and I was able to read the whole thing. But for Commissioner St. John's benefit, normally when we receive letters that are more than one page after Monday at noon, we typically don't allow them to go in the record, simply because as we go through the ethics training that you do every other year, one of the things they try and teach you is that when you're at the hearing, you're paying attention to the testimony given both by staff and by the public, and to peruse a letter or to view it while they're giving testimony is, I don't know if they consider it unethical, but it's certainly inappropriate. So, and I would like to warn counsel that in the future, he needs to make sure he gets the letters in by 1 o'clock on Monday, or by noon on Monday. Although this one is 5 pages, we have had some that are, I would consider, mini novels, where they're 50, 60 pages, and that certainly is inappropriate to get those on a Tuesday when the hearing's on a Wednesday. So if Commissioner Cooney wants to make sure everybody's read it and wants to put it to the record, I'm going to agree this time, but probably not in the future.
Do you want to make a motion to admit the letter dated August 1, Commissioner Blau?
So long as they're from Commissioner St. John and Commissioner Brown that they have read the letter. If they have not read the letter, then the answer is going to be no. I wouldn't want it in the record.
Commissioner Brown?
Yeah, I got the letter yesterday afternoon, and I did have a chance to read it.
I got it yesterday afternoon, and I read it last night.
Okay, we've all read it down here, Commissioner Blau.
You're off.
I'll go ahead and make a motion.
If you prefer not to make the motion, we'll get someone else to make it.
Oh, sorry, I didn't realize I was turned off. Yeah, I do want to make a motion to put it in the record.
Second?
I'll second.
Thank you, Commissioner Farini. We'll vote separately on that and then come back to the item in chief.
Commissioner Brown.
Aye.
Commissioner St. John.
Aye.
Commissioner Farini.
Aye.
Commissioner Blau.
Aye.
And Chair Cooney.
Aye.
Motion passes 5-0.
Okay. Thank you, Commissioner Blau, for applying the brakes there. It's a worthwhile point, and one that tends to repeat. So now we're ready for the vote on the appeal.
I don't believe we have a motion yet.
We don't.
I'll be happy to make that motion. is to follow staff's recommendation to uphold appeal case number 16 APL 24, make the required findings for denial of the project as specified in attachment A of this staff report, including CEQA findings, determine the denial is exempt from CEQA, pursuant to state CEQA guidelines, section 15270A, included as attachment C, and deny the project de novo case 16 LUP 0364, thereby reversing the decision of the director.
Do we have a second?
Second.
All right, Commissioner St. John is seconded. Now we're ready for the roll call. Thank you.
Commissioner Brown.
Aye.
Commissioner St. John.
Aye.
Commissioner Farini.
Aye.
Commissioner Blau.
Aye.
Chair Cooney.
Aye.
Motion passes 5-0.
All right, thank you, everyone, and thanks to the parties in council for excellent presentations today. It's very helpful to have the preparation that you've all given us the opportunity to have. So, and to staff too. Very difficult case to present, and you did a great job. This is the only matter before the commission, so we will adjourn.